to Disputes Decoded with me, Chris Campbell. This is an ArbTech podcast series where we will take a deep dive into a variety of legal tech issues by way of candid interviews with selected subject matter experts. Technology has, and always will, have a profound impact on dispute resolution. And in this series, we'll give you insights into where we're going next. We will demystify complex concepts, decode the jargon, and provide practical insights on advancements across the legal tech space. Join us as we navigate this future where law and tech converge. Welcome to Disputes Decoded, where we download the field of arbitration into the future. Welcome back to Disputes Decoded by ArbTech. Still serving as your host on this fantastic voyage into tech is me, Chris Campbell. Last episode, we kicked off this series by talking with two esteemed guests, Colin and Rahnema, on their work in the online dispute resolution and technology space. In particular, how AI is being used to resolve disputes, especially in arbitration. We talked about things like increasing the speed and efficiency at which work can be done, a duty to disclose usage in AI, and, well, will courts and arbitrators be used in AI? We touched on those topics and we get into those even more in the second part of the episode. You could imagine being able to write a book in a weekend, so imagine being able to make lengthy submissions all within a couple of hours. That's the power and that's the potential of AI, and that's what we talk about a little bit further. So as we go back into the conversation, we pick up right where that conversation left off, discussing the potential use cases for AI in arbitration and how that could impact the field. So stand by as we get back into the episode. I know anecdotally I've seen when I talk with law firms about how I as an in-house counsel might look at the practical uses for generative AI and the tech as it currently exists, is allowing people to do stuff faster. So if you have a research task that would normally take 100 hours or a drafting assignment that might take hundreds of hours, well now, that can be done in a fraction of a moment, a fraction of the time, even if that's half, even if that's a fraction of that at some point, the end result is that's less billable hours. And so the question that sort of fundamentally faces law firms is, how do they adjust for that? How does the business model change? And, it really becomes a question of value add versus time input. And maybe that's a question that's always been sort of approaching law as an existential question. And this technology sort of makes it come to a head.
I've got a good friend, Shannon Salter, who was the former head of the Civil Resolution Tribunal in British Columbia, which is one of the most advanced ODR-based courts in the world. And I remember being in Australia when she was doing a presentation to a lot of the legal leaders there. And somebody said, "What about the reduction of my billable hours?" And Shannon said, "If you have a job that's based on inefficiency, you should not have that job."
I'm taking that. Cool. Yeah, I'm taking that.
That's like, I was trying to, seduce these guys and romance them, and she just gave it to them straight. I was like, go Shannon. The same argument could be made about the word processor. The same argument could be made about the Xerox machine. The same argument could be made about email and the internet. There's always things that disrupt the model. Now, I think, we can talk about the problems with the billable hour and the way that the legal services are currently constructed. But I do a lot of trainings on AI now. We just did one yesterday, and showing dispute resolution professionals how they can use some of these tools in a creative way. There's some things that the generative AI models and LLMs are really good at right now. As Ramin said, I think generating documents out of templates and things like that's incredibly good at putting those things, but always a first draft. I say that the way the technology is now, it's a little bit like a really skilled intern or paralegal in your office. And you can say, "Hey, go put this document together for me." And it'll put it all together, but you've got to review it and go through, because sometimes it'll get things wrong. So heard the story about the guy who had the ChatGPT generate his briefs and submitted it in a court. Anybody who does that, you deserve what you get, because, you got to check the output. But it is questionably a very helpful thing to have a digital assistant right there who in 1 minute can give you a really robust first draft. And as I say, these tools are getting smarter all the time. So you can train it on content, you can give it templates, you can show it, you can give it very clear instructions. And we're all going to have to get really good at being what they call in Silicon Valley prompt engineers, which means asking very specific questions. And it's not only positive prompts, like give me a document that does X, Y, and Z. You also want it to say negative prompts, like I don't want it to do, A, B, and C. So we're going to have to learn these skills. It's a little bit like having a genie, like having a magic lamp. The danger in a magic lamp is not the magic lamp, it's the wisher. So the risk is now on us. Our skills are going to have to change. It's not going to be just opening up a blank Word doc and then typing everything from scratch. We're going to be working with these generative tools that are going to be putting components together. It could be brainstorming. Another thing that these LLMs are really great at is summarizing. So taking enormous amounts of information, reading it all, and saying, what are the key arguments of this side? What are the key arguments of that side? What are the weaknesses of this side? What are the strengths of that side? Having an algorithm that can help us with that, it really increases our efficiency. And I've had arbitrators say to me, am I going to lose my job to AI? And I say to them, well, no, I really don't think we're at a point, at least not in the near term, where AIs are going to be taking arbitrations from other arbitrators. But arbitrators with AI are going to take cases away from arbitrators without AI, because these assistants are, your clients are not going to want to pay you for 100 hours of doc review if a competitor is able to use an LLM and analyze all those documents and pull out the key points in 5 minutes. So these are just tools for the toolbox. It's not the Terminator. It's not, what we call AGI, artificial general intelligence, where the AI sort of makes its own calls and it's deciding what to do. It's only going to do what we ask it to do. But every area of society is going to be transformed by these tools, including ours. And I think if, for instance, if you were a lawyer that refused to use Lexis or refused to use a word processor, over time, your clients would just lose patience with you because of your inefficiency, and they're going to go someplace else. I think that's what it's going to look like for AI in the near term.
Well, that's right. And one thing that I will add, because hopefully for folks that are at law firms listening to this, no one is dragging you, is compelling you to learn how to use these tools. You certainly don't have to, but you now require more time to do those things. Like Colin has just said, clients are not going to be willing to pay for that. And so, sure, if you need to do that, fine. But now your pricing is going to have to be competitive with folks that are using those things. And so at this point, that's where the conversation is going, is that to the extent that processes can be made more efficient, things can go faster, costs can be cut. It's kind of the old adage of from the old industrial revolution, man versus machine. Why would I pay someone to conduct a task that a machine can do half the time, less cost?
I think Colin's message about arbitrators with AI will replace arbitrators without AI. I think that is clearly the message here. And we really need to take that seriously, because as we go forward, these machines will only become more and more capable. They have a lot of problems right now, which means a lot of their benefits that we talk about here may not be as immediate, at least, and we can talk about those as well. But as we go forward, we just must be more familiar with how they work and how we can use them in practice, and also be aware of the risks that come with their usage.
One of the things that we've seen, especially more recently, is organizations dedicating resources and trying to consider putting guidelines of how AI can be deployed. Biden administration has commissioned research into the usage of AI across the American government. More particular to what we're talking about, the Silicon Valley Arbitration Mediation Center has its own set of guidelines as it goes to the usage of AI in arbitration. Let's get even more granular. One of the topics that comes up within one of those conversations is disclosure about the fact that you've used AI. I'd be really curious to hear who of you's thought about it, because I think on the one hand, there is this, it seems like on its face, oh, well, obviously you have to disclose whenever you've used this sort of thing. But again, maybe to a point that you made, Colin, how useful is that really? Because at the end of the day, it is the user who is signing and saying, I am putting my name in my judgment to verify and to certify that this is my work product. AI, does that make a difference? I mean, do we have people say, oh, did you use Westlaw or Lexis when you put together your brief? I mean, how dispositive or how useful is that information really? But maybe I'm not going deep enough on it. I'd be love to hear your thoughts, Ramin or Colin, on that.
I can start some thoughts on this. I'm actually wrestling a little bit with how much disclosure I would think it's appropriate in a commercial arbitration setting, because you can have a situation where one party is using a very powerful generative AI and the other party is just not doing that. Do they need to be disclosing that? I don't really see the difference as to what would be the case if that party had very powerful legal counsel, simply, right? And the other party just didn't have the financial means to have that. What is the difference there? I can definitely see situations where an arbitrator, like the courts in many instances that I've seen, that are concerned that they're going to get evidence that's generated by AI, and they require anyone that goes into that court or to that tribunal to disclose if they have used generative AI to generate any documents. I can understand that point because you as the arbitrator may be on highlight to see, oh, is there generative AI used here? So I may need to be more careful to look for any made up or any hallucinations in the machines, for example. But generally, I think the approach that's mentioned is one of the approaches in the Silicon Valley mediation and arbitration guidelines proposed is that disclosure if it's going to be materially affecting the procedure. So if there's documents that are going to materially affect the arbitral procedure, then they should be disclosed. I think at this point, that seems to be a reasonable point of view to take. But I'm happy to hear Colin's point of view on this matter as well.
Yeah, I think we are in the middle of this transition. I'm doing a presentation later today with someone on AI, and they said, "Yeah, I've never really seen ChatGPT before." It's like, really? You've not seen ChatGPT? I mean, I think we have a lot of people that still they don't know what this technology is. They don't know how it works. There's a lot of mistrust about it, and we are seeing AI permeate all of our tools. Microsoft is now putting Copilot on everybody's Windows desktop, and they're embedding it in Word and in Excel and in PowerPoint. You can go into Canva and say to Canva, make me a 10-slide deck on arbitration and AI, and it'll put it all together with all the graphics. I think it's going to make some people feel better in the near term to say, hey, we want to disclose when AI is being used. I think another concern, and I think this is a valid concern, but again, it's something that's being resolved right in front of our eyes, is the security and confidentiality of these tools. Because if you just log into ChatGPT provided by OpenAI and provide all the details of your case, well, that's going into their publicly accessible data repository, and they're using that data to train and refine their AI. And of course, a lot of people in an arbitration process don't want their confidential data being put into those processes, but that's something that's being solved. And I think very soon we are going to be able to get secure instances of these LLMs that we can use, and they can deliver value for us. And then when we're finished, we close it down. It deletes the data. It doesn't share that data. So I think in the interim, the Biden proposed regulations are good. I think most of these AI companies are clamoring for regulation. There have been a lot of examples of generative AI, like Microsoft created an AI chatbot a few years ago that didn't have appropriate guardrails in place, and a bunch of trolls came in and trained it to say all this racist, hateful stuff. So they had to shut it down. One of the things that I think is a big breakthrough and is often unheralded about ChatGPT is that it won't do that. If you say, hey, I want you to generate a DALL-E picture with this face, it'll say, no, I don't do that. How do I build a bomb? I'm not going to tell you that. Like, putting these guardrails in place for AI are very important. And I think we often see technologies, disruptive technologies, when they're released, people don't think adequately about some of the negative impacts, the negative capabilities. I mean, you can use Microsoft Word to write a mediation training guide, and you can also use it to write a hateful screed. Nothing about Microsoft Word that prevents you from doing that. It's just a tool. It's sort of a valueless tool. I think AI is kind of like that too, but its power is so extreme because it sort of does make us superheroes. I mean, we could write a book in a weekend now. I mean, that's just inconceivable to our grandparents. But by putting these guardrails in place, by having regulation, by being able to ring fence some of these technologies, I think that's all about building trust in those tools. And eventually, it's not going to make sense to disclose where AI was used, because it's going to be used everywhere. You probably would have more luck if you said disclose when you don't use AI. But I think it makes people feel, at least in the interim, having that transparency, it gives us a little bit more clarity. And I think that's what they're trying to do with some of these intermediate regulations. They want to put the guardrails in place to build trust in the technology, but not such strict guardrails that it'll hamper innovation and put us behind others who don't have those guardrails. So I applaud what the Biden administration is doing. The government was way behind on privacy, and by the time they finally got around to thinking about it, it was already done. The horse was out of the barn. The good thing about AI is I think the companies who are generating it and the regulators, they're getting smart people into government, and at least in the United States context, I'm sure this is happening in the EU as well. They're saying, hey, we want to get smart about this because this is such a potentially disruptive technology. Let's figure out how we can minimize some of the challenges and maximize the benefits.
Ramin, same question.
Regulating AI, it's a really a tightrope, and we have to be careful how much we regulate it. Speaking from the perspective of arbitrators, we don't really want to be regulating this thing out of existence. So no strict regulations to say you must disclose AI, otherwise this award needs to be set aside. I think there are enough safeguards within arbitration, say due process or public policy, so to speak. These points can actually keep us safe from over-reliance on AI as it can happen. So if we're going to be regulating AI, I definitely think a approach as to the form of a guideline that the parties can adopt, that would be the best approach. We don't want to be changing the legislations that we have. We find that it's pretty much impossible, for example, to change the New York Convention at this point. And also to say it's going to take a long time. And by the time we get that legislation within arbitration, at least, the AI may have moved on to moving different techniques. And in that sense, a guideline that can be updated as we go forward, as AI changes again, which is, as we saw, it's quite possible that it makes another huge jump in a year or two. Also keeping it loose enough so that we can work with AI and not stifle us compared to, say, commercial courts, where they are, from what I've seen, are very open to using AI. And I think they also have fundamentally better tools at their disposals, given the confidentiality, quote unquote, problem in arbitration as far as data goes.
I think all of that is probably well seated and well said. Overregulation is probably not the answer, because then I think, well, what you just have is like a sort of weird black market where people will be using AI but just try to hide it. But also being thoughtful and responsible about the fact there is the propensity for misinformation, for abuse of these tools. But as with any tool, using best practice, implementing best practices for the developers that are putting it out there, making sure that they're being thoughtful about how they do that. I mean, there's a reason why you can't just walk to your local Walmart or whatever your local store is and get a grenade or build, some sort of highly technical thing. It's always done with oversight and with sort of forethought as to how these things could be implemented. Honestly, we're all sort of still in this waiting phase of trying to really understand what we're talking about and how we're talking about it. So in order to rule make about it, you got to really understand it.
Yeah, that is the problem really with these language models, is that you can use it once and it's incredible. The results you get is amazing, but then you use it for a different use case and then you get such wrong answers that are sometimes dangerous, because we're talking about hallucinations, which is when these machines just make up information that doesn't exist. An even more dangerous part of hallucinations is that sometimes these machines, they actually mix and match information that have nothing to do with each other. And it looks right, looks great, but it's even more difficult to find that problem in that as you're looking at it, and if you don't know if generative AI has been used. So I think it makes sense to be on alert now to see, is there generative AI used in the proceedings or not? But as we go forward, this should become less and less of a problem.
Yeah, let me just piggyback on that, because I think that there's so much excitement about these LLMs. People think that that's the extent. We're going to have a digital arbitrator that's just a ChatGPT plus some legal research. But I think it's actually going to be a mixture of a wide variety of what we call machine learning techniques. So the traditional approaches, where you take a very large structured data set and you train on that, a tool like that can generate insight that an LLM won't generate. So if you combine those two things, that could be very powerful. You could also build an API that evaluates a programmatic interface that reviews the outputs of LLMs and checks them and make sure that it can validate all of the assertions that it makes. And if it says, hey, no, this is wrong, it can push it back to the LLM and say, hey, you need to correct these errors. And there's already some research that shows if you provide pre-instruction commands to an LLM to say, go stepwise through everything and make sure you minimize risk, it will do a much better job identifying and eliminating some of those hallucinations. So we're making progress on all of these fronts. These are the early days. We're still in the Wild West of this technology. But I do think it's going to be a combination of all these approaches together that's going to end up delivering something that can be consistent and trustworthy. And that's when I think people are going to say, okay, we're not so worried about making sure that these AIs are always under human supervision and that we disclose every time that they're used, because that's a problem of not having trust in the tools. But once we establish that trust and I say have quality metrics that establish the consistency and the value of the output that they generate, then I think you're going to see it hit more ubiquity. We'll get past that tipping point.
A lot of threads to pull there. I will say, even in my own usage of a technology like ChatGPT, one of the most fascinating things is sort of being able to get it to write in the style of something. If you're trying to write something that's in a radio announcer style, or if you have a favorite author or thinker, you can sort of get them to sort of mimic those things. Considering, okay, that's Chris's really basic and pedestrian usage of it, but what do you do when you have an arbitrator who has a bunch of writing, or their awards are everywhere, and you can have a legal generative AI or a large language model that can say, okay, take arbitrator so-and-so's decisions and write an argument on this topic. And of course, even if you edit it a little bit from there, I mean, you're more or less reflecting an argument directly back to what someone wants to hear. There will be a point, I think, when we are there, and that is what's happening. And we have to figure out what the practice of law looks like, and especially arbitration looks like once we reach that nexus.
Something about that, Chris, it rubs me the wrong way. I don't know why. The fact that we can use the AI to write in the style that would be convincing to an arbitrator. Somehow it doesn't seem ethical, but I don't know why. It seems like a little bit of manipulation going on, but very debatable. It's surely very effective.
Well, a common arc or storyline in a lot of our sci-fi or fantasy sort of worlds is the protagonist, the main character, has to face off against the doppelganger of themselves, Luke versus Dark Luke and Dagobah.
I think about Mario when you have to race against your prior best time and you see the ghost Mario running alongside you. So maybe it's something like that. Yeah.
Thanks for bailing me out. And if you want to go to Mario 64, you have to fight Metal Mario. So there, I've redeemed myself. And
it's a safe space for nerds. That's what we said at the beginning. So.
Well, look, guys, we are approaching the end of our time together, and I knew that the time would sort of zoom by here. I guess as we get ready to wrap up here, maybe any final thoughts or predictions you have. We've done that a little bit already, but maybe taking that forward about how AI will continue to evolve, impact the practice of law, or maybe just things that are on your mind as you sort of think through this, because there's a lot to say for sure.
I can begin, Colin, if you don't mind. I got
Sure.
two things on my mind, really, as far as we go forward. I think currently many of the benefits that we talked about as far as generative AI goes, they are still not into fruition. We still need to double check and triple check everything. So that means that we're not really feeling the effects of efficiency and faster decision making that we talk about. But as we go forward in the near future, in the next couple of years, and these machines make less and less mistakes and are more and more accurate, I think we can really feel the tangible benefits that they bring to the practice of law and arbitration. And the second point that concerns me a little bit within arbitration is, again, the question of confidentiality. So these machines, they really thrive on data. Data is their bread and butter. In the legal field in general, we don't really have access to as much data as we have, say, as the OpenAI makers of ChatGPT have had to make ChatGPT. So that means that these legal machines, if we're going to be training them on arbitral legal data, we're going to have a challenge there, because these awards are either fully confidential or they are in the hands of the institutions or a few companies that have them. So that means that not everyone is going to have access to train a model on all the arbitral awards that we have in our hands. So possibly a slight change, maybe even in the confidentiality culture that we have in arbitration, and whether we can be promoting more and more publication of awards, especially in redacted form, and somehow coming up with a sort of incentive for parties to try and be pushed to be open to the idea of having their awards published. I think that would be necessary if we're going to be competing with the courts as we go forward in this age of AI.
Excellent point. Excellent point. I will say arbitration is changing technology. I mean, I run ODR.com. We are building software to try and automate and bring AI into the arbitration process. But technology is changing arbitration. And that's why I really like the point you're making, Ramin. I think we need to think about how these new tools shape the work that we do. And we need to be open to adapting our practices and arbitration as a whole to leverage these new tools. I think back to the movie 2001, where there's a scene where prehistoric man, one of the prehistoric Neanderthals, picks up a bone and realizes, wow, they can use this as a tool to smash things. And then they throw it in the air, and then Kubrick jumps to a bone-shaped satellite. And the point is, it's just tools. It's just tools. Our tools are just expanding. And that's the way that I feel about AI. We now have this new tool. It's in our toolbox. We're trying to achieve the same thing that the forefathers and foremothers of the arbitration field are trying to achieve: provide fast and fair, impartial, confidential, effective resolutions to disputes. But now we have this tool, and we've got to figure out how to use it. So I think we need to be open to it. I don't think there's any way. If my grandfather always used to say to me, don't build your business where the highway is, build your business where the highway is going. And now that we have this tool and we see where the arrows are pointing, we need to build the field. We need to evolve arbitration into the direction of where these tools are leading us. And that means there's a lot of hard fundamental questions we need to ask ourselves. But I do believe that these powerful capabilities that AI extend to us can be used in a way to achieve the same objectives that people had for arbitration 100 years ago, even though they couldn't even conceive of the capabilities that we now have at our disposal. So we need to build our own tools. We need to build our own data sets. We need to do our own reviews. We need to ensure we care about procedural justice and transparency. But I remain a glass half full nerd. I'm excited by where this is going, and I think it's going to help us make arbitration better. So let's get to work.
Colin, I love your example of 2001. And if you don't mind, I'm going to try and somehow implement it in my thesis as I go forward. Because
I'd be honored. You don't even need to footnote me.
That's well said. That's well said. And look, this has been a great sort of a two-part conversation. So we appreciate you guys sitting down for both segments of this. And a really fascinating conversation. There's a lot of threads still to pull here. And listeners, stay tuned. Follow both Ramin and Colin. And in fact, to that point, Ramin, where can people follow your work or follow things that you're doing and developing?
Yeah, the easiest way is to just email me or on LinkedIn. I'm not super active on the social media yet. I got to get on that. But as I get forward, it's going to be mostly on LinkedIn or the email that's on the University of Groningen. I'd be happy to talk to anyone who is interested or working in this field, and we can exchange ideas. That'd be great.
Yeah, you said at the beginning of this meeting, I didn't speak a word of Dutch, but now you say Groningen so convincingly now. So I know you at least speak at least one word of Dutch.
No, I do speak Dutch now, Colin. I'm happy.
Okay, good. There you go. There you go. You've absorbed it. Well, I think the best place for me is probably arbitrate.com, mediate.com, odr.com. But I do urge people to also look at odr.info, which is the website of the National Center for Technology and Dispute Resolution, and also ICODR, the International Council for Online Dispute Resolution, icodr.org, for best practice standards around ODR. But please, we're all going to be doing this together, so don't hesitate to reach out.
Ramin, Colin, thank you so much for your time, and thank you for coming by the show.
Thank you,
Thank
Chris.
you, Chris.
It was great.
So there you have it. A fascinating and interesting conversation. We had to break it up, as you can see, into 2 episodes because there was so much to talk about. And frankly, we probably could have gone even further. But there were interesting questions posed, I think, in the conversations between Colin, Ramin, and I. What are the guardrails for this technology? How will it change the practice of law? What do regulations look like? These are all important questions that are on the minds not only of the technologists that are innovating these technologies and these tools, but especially for the lawyers that will be using them, that will be employing them. As we said during the episode, it's probably naive to think that it will never happen or its day will never come. The question is, how will we deal with it when its time comes? So we pass the question off to you. Listeners, audience, what do you think? If you have thoughts about this, about how AI could impact the practice of law, how you've seen it in your own practice perhaps, let us know about it in the email or in the comments of where this episode is posted. In fact, we'd love it if you engaged with us even more. So don't forget to follow ArbTech on LinkedIn or on its website. And of course, if you really enjoy the show, to leave us a review. And of course, let your friends and colleagues know about it. This is a community conversation, not just 3 folks with a microphone talking. So we hope that you'll tune in again for our next episode. In any case, thank you for being with us. Thank you for joining us on this first series of episodes, this first couple of episodes, and we look forward to bringing you more on more technology topics in the future. Oh, and I should say, if there's a topic in technology with regard to disputes that you want to hear about that we haven't covered, let us know. We'd love to talk about it or maybe even rehash some of the old topics at some point. So thanks so much, and we look forward to seeing you next time. Thanks for listening to Disputes Decoded by ArbTech and Tales of the Tribunal.